A person who is named as power of attorney owes the person who has named him a duty of care if he's going to handle his affairs, and he is a fiduciary, just as someone who is a trustee of a trust or an executor of an estate or administrator of the estate. So he owes that person the duty to handle his care appropriately. Now, that doesn't mean that he has to make the best stock investments or the best decisions, as the sale of the house. It's not that type of thing, but he owes him an obligation to do his best, and to everything that is done is geared for that person. One of the issues that's over the last few years, particularly with older power of attorneys, is there was a line in the power of attorney that said that the power of attorney could make gifts. Well, the court ruled on that sure, you can make gifts, but they still have to be for the benefit of the individual. For example, you can make gifts to reduce that person's estate for estate tax liability. You can make gifts potentially to get that person qualified to go Medicaid. You can make gifts to that person if he had a history of gift giving to charities, and it made that person feel good, and there was a history of that. But you just can't just give gifts to enrich yourself. And so that power of attorney needs to appropriately act for the benefit of the person individual, to the individual, and can theoretically be found liable for civil damages if he abuses that. Or in some cases, power of attorneys have gone to jail for misusing a power of attorney and taking it to enrich themselves. I have had cases where, sadly enough, children have gone to jail for taking money from their parents' accounts. Sad, but it does happen.